I'm Carole Taylor. On this edition of Journal, we take a different look at the disorder on our streets. Boy, it's been a bad couple of months. There was the machete killing and hand maiming near Queen Elizabeth Theatre. Last week, a sucker punch dropped another stranger outside of the Hudson Space store, followed by the knife attack on two individuals in a store on Robson Street in the middle of the day. What is happening that led Vancouver's mayor, Ken Sim, to say, "Vancouverites are sick of this crap," quote, unquote. Unfortunately, there's enough blame to go around for this deterioration in our cities, and a lot of finger-pointing. But let's start with the decriminalization experiment that led to wide-open drug use, safe supply drugs being diverted to young kids, a shortage of treatment beds or involuntary care for those who are seriously mentally ill, or the revolving door of catch and release for violent repeat offenders. Sitting in judgment on all these issues is our court system. Broadly speaking, what is holding up real bail reform? Why are repeat violent offenders so often back out on the street? Is it a lack of facilities or policy direction? And what about access to justice? We hear far too often about delays resulting in charges being dropped. Not enough judges, not enough courts? Never mind the prohibitive cost of a lengthy trial. Today, I'm joined by the Honourable Robert Bauman, former Chief Justice of BC, former Chief Justice of the Court of Appeal, BC. Recently retired, I want to ask him what the courts are doing right, but also where are the weaknesses and what are the solutions. Back in a moment. Chief Justice Robert Bauman joins us today, and I want to start off by thanking you for your service. You've been in the world of judging for 27 years. I always regard that as public service, so thank you for doing that.
Thank you. I appreciate it. And it is public service, but it's extremely rewarding for the individuals that get to do it.
So on that, when you were a little guy, You apparently wanted to be Chief Justice someday.
Well, I wanted to be a judge.
A judge. And so did it turn out the way you had hoped?
Yeah, it did. There's a certain amount of right place, right time for things in life that happen to you. But everything worked out. I practiced law for 21 years with some very good firms, made a lot of good friends at the bar, learned a lot. And then in 1996, when I was just turned 46, I realized my ambition to become a judge, and that was really the end of the ambition. And everything after that was simply gravy, if you like.
So anything surprise you about being Chief Justice?
Yes, the deference the office automatically attracts. You have to get your head around the fact that it's not you, it's the office. And I've noticed that particularly since I've left office. My observations don't carry the same weight. So it's a great job. It's not easy from the point of view of managing very smart people who are completely independent. You've heard the expression herding cats. That suggests that you can actually direct them somewhere. Independent judges make very challenging colleagues, but very rewarding experience to work with them and to find the common consensus as a court moving forward on issues to the extent that we do have a consensus on issues, which is, you realize we keep that fairly infrequent because we approach every case independently and on its own merits.
Well, we'll talk about the strengths and the weaknesses of our court system, but obviously the burning stressor right now for the public is the repeat offenders, violent offenders that are on our streets. And everyone's looking for someone to blame, whether it's provincial government policies, federal government policies, but the courts also are taking some shots. From your experience and your point of view, what responsibility do the courts have in this problem?
Well, sure. To the extent you see that repeat offender on the street, I have to say to myself, something's gone wrong. Our bail laws, of course, are what guide judges in making bail decisions, and the presumption has been release under that legislation that we didn't craft. We're rather administering and interpreting. However, in every individual case, if all the facts are before the judge, the right decision should be made. And if it isn't, in the minds of most people, and this is the kind of decision where most people can second guess the judge, can be quarterback judges. Where that happens, something's gone wrong. Perhaps the judge hasn't been given all of the information. Crown Counsel are stressed out on the amount of work they're undertaking individually, and they may not have all the information to put before the bail judge, and in that kind of case, decisions are made that perhaps don't reflect the criminal history of the individual before the court.
Yeah, that is tough, because when you, as in the public, hear the story afterwards and hear somebody has had 9 convictions and releases and they're back out and they do damage again, you sort of think like, so you're saying maybe all of that information wasn't before the judge?
On occasion, that's exactly what happens. Things are going too quickly or whatever. Some of these databases aren't instantly available. If that happens, well, we can explain what happened. But where we're seeing, with knowledge, repeat offenders being released to offend again repeatedly, the legislation now would allow the judge to on the tertiary ground, say no, or the secondary ground, which is likely to offend again, to say no to bail, or the legislation can be amended. But you know, that's a cure-all that isn't always necessary. We have very good bail laws in this country. We have the criteria that the legislature has directed us to take into account, which are the types of reasons to keep somebody in jail.
For instance?
Likely to reoffend, seriousness of the crime, the strength of the case, rather, and finally, the trust in the administration of justice, the third ground. And judges, perhaps in the past, because of appellate decisions, have been cautious in using the third ground. But in a situation where you have that repeat offender, in a situation where repeat offenses are endemic in a particular area, Crown Counsel can bring those facts to the attention of the judge, and sentencing and bail decisions in certain areas can change. For example, we had a marijuana grow problem in the central British Columbia for a number of years. And what happened there was the local crowns started educating the court as to the ramifications of the general problem, as opposed to simply this particular offender. And that then the judge was armed with the information necessary to say sentencing has to change in this area for that reason. So presumably a prosecutor could present the case in the context of all of these repeat violent offenders and acts of violence against strangers as the context within which this happened, and the judge would be able to take that into consideration? I believe she could. I believe she could under the third ground that I mentioned, the trust in the administration of justice. That would be reviewed by a court of appeal. But, you know, I think we have to be imaginative in using the existing laws, which are very well crafted, by the way. People roll their eyes, but the fact is Parliament does a pretty darn good job giving us the guide rails for judicial discretion. And sometimes it requires a bit of imagination in the use of those guide rails or bumping up against them. And trial judges have to be courageous in doing that where necessary. And frankly, appellate courts have to support them. One of my friends who's a former judge said one of the problems is that judges are, he believes, overworked, and they don't have facilities around them to help with the situation. So if you start keeping everybody in rather than putting them on bail, they don't have facilities for that. Absolutely right. We would be taxing facilities. I mean, the United States incarcerates a very high percentage per 100,000 population. We're much lower, but we're still higher than many Scandinavian countries, etc. The fact is, incarcerating people is expensive, there are limited resources, and it's not very effective. But at times, you've got to draw the line, and it is appropriate, totally appropriate, to crowd those jails with somebody who simply cannot be controlled in the community.
And so you are saying this from a bit of distance now because you've got more perspective away from the day-to-day. Do you think the courts are responding?
I believe they are. I don't know how they couldn't take notice of what they read in the newspaper. I don't know how they couldn't take notice of what's going around us in this city and at times. It seems pretty obvious. So I would hope that we've been sensitized, the judiciary has been sensitized to the problem, sees it as in places and times as an endemic problem, and respond appropriately.
It's a funny line judges have to walk because you have to be, in a sense, isolated from the community so that you can make judgments, even-handed. But on the other hand, if you're so out of touch with what society is thinking and worried about, then that also affects judgment.
Absolutely. Judges shouldn't be guided by simply the whim of popular, commentary. And indeed, in the 50s and 60s and 40s, judges were apart. They stood apart. That was the expression. And they stood completely apart from the point of view that their interaction with the rest of society was extremely limited. We've liberalized that quite a bit.
We're just going to take a short break and we'll be right back because I want to talk about delayed justice. Back in a moment. Bob Bauman joins us again to continue this conversation. I guess now that you're retired, I'm allowed to call you Bob?
Absolutely. The Honorable Robert Bauman's a bit of a mouthful.
Yeah, it is. So you just touched on a point about people believing in the system of justice. You know, I don't want to keep going on about bail reform, but things like that, when society feels they can't trust whether it's the courts or judges, undermining the institution is a very dangerous thing in a democracy.
Absolutely. You know, the judiciary, the third branch of government, is critical in our system of government to protecting the rule of law. And as an institution, generally, if it's not trusted by the public, we lose all relevance. Potentially we lose our viability.
And so that's a concern of yours. I know that you've been working on that. One of the issues that you've talked about is access to justice. And when people see justice delayed, then that is the cliche of justice denied. And what I'm referring to is when a court case seems to take so long, so many years, and the Supreme Court said after a certain time, off it goes.
On the criminal side, they said that in the Jordan decision. But yeah, timeliness in the delivery of judicial services is absolutely critical. Jeff Cowper, a well-known senior litigator in Canada, has written extensively on the idea of timeliness and reminding lawyers and judges that our reaction to issues brought before us has to be a timely one and dispositions have to take place in a timely fashion. Court cases sometimes do take a long time. Sometimes it takes inordinately long. However, I mean, it takes a year for the lawyers to get organized. Let's take a civil case. It takes a year for the lawyers to get organized to do the pretrial procedures they have to do the discovery, production of documents they have to do to get ready. And then their calendar, of course, guides where they can put a trial. So there's going to be delay inherent, appropriate delay, but where it's not appropriate, where it's simply a reflection of inefficiency. That's where we have to step in and remember that we're there to serve the public. A system that doesn't deliver justice in a timely fashion will not be trusted and will not be resorted to. They'll be going to other dispute resolution forums. And critically, the legislature and parliament may say, gee, the courts aren't working. Let's create new tribunals that aren't protected by judicial independence as we know it, but that may have the appearance of being more efficient.
So do you think that's a good idea or a bad idea?
Well, I think it's a bad idea, but I understand what might prompt it. I resist it. I think the job of chief justices and courts these days is to do the job well enough that that kind of reaction by the other two branches of government is not encouraged, and is not pursued.
Well, just imagine an average family, and you've got a court case that really should go through the court system. How can you possibly afford it?
Quite agree. Access to justice for ordinary Canadians is the single biggest challenge we face. We've got to figure out a way to make family justice accessible to families and at the same time not destructive of families and children in those situations. We know that family conflict and family conflict in the courts has a physical effect on children. It delays their development, it impacts their development, it leads to problems downstream for children. And that's a medical fact. We've got to address a system that recognizes that, makes family law accessible to families in a timely fashion. There's where timeliness is very important, and is affordable.
So one example that's come to my attention is, and its unintended consequences. The idea was good that you have to, in these cases of families, let the children's wishes be known. And I think it's called children's wishes.
Yes.
And so that sounds right. Except that judges often feel like, well, I'm not a psychiatrist or a sociologist, so I can't make that decision. So therefore, you should get an assessment. Well, if you're a wealthy family, you go off and you get somebody who does this for $5,000 or $8,000, and so be it, and it moves on. But for most families, you go, well, I can't afford to pay for that myself. So then the court will give you someone who will do that. But that system's so backed up, it might take a year and a half before you get that assessment back before the court. Think of that poor child.
Oh, a year and a half in a child's life, as you know, is forever. We should be talking days and weeks. The family law, that kind of pretrial assessment of children and custodial arrangements has to be available. It has to be resourced by the province, in my view. And judges have to do everything in their power to ensure that lag doesn't happen. And that means doing, some imaginative things. Early intervention, which we're doing in the provincial court, and they've been doing in the Supreme Court for some time as well. Early intervention is where the judge gets involved at an early point in the process to try to delineate the issues, maybe reduce the issues, and see if some of them can't be resolved right at the start. And that's critical. And the other thing we need in family law, in my respectful view, and this is not popular with the trial schedulers, we need the continuity of judicial management of individual family cases. Too often you see a family law litigant, I've talked to mothers and fathers, who have been to court 8 or 9 times, and they've been in front of a different judge every time. And they're starting all over again, as it were. Even though the judge tries to prepare, they're effectively starting all over again. And if there's a bad actor in the team, in that particular piece of litigation, that bad actor is encouraged to continue conducting him or herself the same way because they're getting away with it.
So from your point of view, when some of these issues we've talked about, does it come down to we need more judges, or do we need more facilities, or do we need more mental health experts involved in the process? Where are the answers here? Right.
I think we need a more holistic approach to family law, and I think the province is experimenting with ways to do that, and the provincial court is as well. So in other words, involving more people in the process, counselors, et cetera. Do we need more judges? I'm never convinced. That seems like a crying wolf a bit.
Have we gotten past the fact we had so many vacancies for a while?
We've improved that dramatically. The boomers are going through the system, and that's what caused the problem. As usual, the boomers are at fault.
They're at fault for everything. Here
absolutely.
we are.
We blame us for everything. But the appointments now are much more timely. I read an article the other day, why don't we just make sure that when the judge gives notice for 6 months of his or her retirement, that on that day of retirement, there's a replacement. It seems like a good idea to me. Mm-hmm. But attracting good candidates isn't always easy. We had a dearth of good applications, not good applications, they're all good. A dearth of applications for a period of time.
Why would that be?
I don't know. I think a lot of people are realizing how difficult the job is. and what a stressor it is. And the travel for young families is difficult. In the Supreme Court, there's a lot of travel. There's 8 weeks of travel usually around the province. I enjoyed it immensely, but I didn't have parental responsibilities. Those who do, not the same situation. So I wouldn't say more judges. I would say looking at ways to move the cases more quickly and efficiently with the least damage to families. Families should be at the center of our efforts, their well-being. Some simple reforms or the use of existing rules.
Like?
The use of the rules that allow us to streamline the litigation, that allow for the summary disposition of some issues, that allow for different modes of adducing evidence. Maybe we get away from the typical courtroom scene. We see affidavits being used as part of the process more frequently. It's the imaginative use of the existing rules and active case management by existing judges and a dedication to the family as the center of our efforts would make a big difference.
Thank you for joining us today. And next time we'll talk about UNDRIP and how it's changed the whole judicial system.
Yeah, we're on the cusp of some very amazing times.
Back in a moment. So what are we to make of our court system? According to former Chief Justice Robert Bauman, our laws are pretty good, but the application of those laws leaves room for improvement. Unlike in the past, where judges were supposed to be isolated from the community they lived in, today they're expected to be aware of the context within which they are making decisions. For instance, the huge problem of violent repeat offenders on our streets, an issue that needs to be addressed if we're going to restore confidence in the courts. Let me know your thoughts on YouTube. Till next time, I'm Carole Taylor.